Hi madam, good evening. We are from group 7. We are going to present about the incorporation of a company. I'm Shalini Raveendran. I'm going to present about the definition and the effect of section 16.5. First one is the definition of incorporation of a company. The incorporation of a company refers to the legal process that is used to form a corporate entity or a company. An incorporated company is a separate legal entity on its own, recognized by the law. This corporation can be identified with the terms like INC or limited in their names. It becomes a corporate legal entity completely separate from its owner. The legal recognition for incorporation of a company is section 16.5. The second one is the effect of section 16.5. Incorporation of a company shall be a body corporate and capable for fit of exercising all the function of an incorporated body and of suing and being sued and having perpetual succession and a common seal with power to hold land but with such liability on the part of the members to contribute to the asset of the company in the events of its being wound up. That's all from me, madam. I pass to other person.
My name is Najwa. So today I will be present about effect of incorporation of companies. So the first effect is separate legal entity. Separate legal entity is a company, is an incorporated association that has a legal personality of its own, independent of the person who comprise it. The principle is known as will of incorporation. There is a distinct entity from its members. The case that established the principle of separate legal personality is the English case of Salmon v. Salmon & Co. Limited. Salmon carried a successful business as a sole trader in boots and shoes. In 1892, he formed a company and transferred his business to that company. So the company had 7 shareholders that included Salmon, his wife and his 5 children. He took the prize partly in 20,000 £1 share, partly in cash and partly in debenture secured by floating charge. So Salmon became a secured creditor of his own one-man company and had claim to the assets of the company in priority over the unsecured creditors in the event of liquidation. After some time, the company went into liquidation and the assets of the company were insufficient to meet the claim of secured creditor and the unsecured creditor. The liquidator found that the secured creditor is Salmon himself, and the majority shareholders decided to pay the unsecured creditor first. So Salmon challenged this and went to the court. The creditor claimed that Salmon was still the owner of the business and liable for its debts. The company was irregularly formed because 6 out of the 7 shareholders were mere nominees of Salmon, and that Salmon and the company were one and the same. The House of Lords held that the Salmon and his company were 2 separate persons, with the result that the business was owned by the company and therefore its debts were the liability of the company and not Salmon personally. Although Salmon owned 99% of the issue shares of the company, he could also be a secured creditor with enforced right against the company in the capacity, because once a company is incorporated, it is separate from the person who formed it. Effect of Salmon's case, the company will be liable for its own debts, and liability company can sign a contract with its own shareholders or officer. So the second effect is can sue and be sued. A company may sue and be sued in its own name. In fact, it must sue on its own behalf according to what rights it has and duty owed to it. For example, in case of Force v. Harbottle, in this case, 2 shareholders in a company brought an action against the company's director. They claimed that the property of the company had been misused. The House of Lords held the injury complaint was an injury to the company. In law, the company and its member were not same. Therefore, the member cannot maintain such suit. It was for the company to sue and not the members. In other words, the company is the proper plaintiff to initiate actions in respect of wrong done to it. Thus, the proper organ to commence the action on behalf of the company is the board of directors. A single director or officer of the company cannot sue on the company's behalf unless specifically authorized to do so.
Hi madam, my name is Siti Noraidilfitri. Today I want to present about the third and fourth effect of the incorporation company. Okay, the third is ability to own property. A company can own property in its own name, which is they can own a nature or figure by their own company's name. Okay, the cases for this effect is Abdul Aziz bin Atan. All the shareholders of the company had transferred their entire share to a certain buyer. Whether the land, which was the main asset of the company, was sold. An incorporated company is a legal person separate and distinct from the shareholders of the company. In the present case, the company did not change its identity or personality. It continued to own its old asset, which is they can have the new asset, but using their own and their old company's name. They didn't change the company's name and own the other asset by their name. Okay, fourth effect is ability to incur its own liability. Liability of a company is limited, but liability of members is limited depends to the type of company. In example, limited by shares or limited by guarantee. The cases for this effect is reapplication by Yi. Yi was a secretary of a company. The company retrenched its staff and matters concerning retrenchment benefit was referred to Industrial Arbitration Code, which had ordered an award. Meanwhile, Yi was appointed as a director of the company. But when the company failed to comply with the award, an action was made against Yi because Yi was the head and the director of the company.
Next is perpetual succession. The company is immortal. It will continue to live until it is properly wound up or struck off the register. Even if all the members die, the business still exists. There are two cases, which is Renewal Tadman and Abdul Aziz Atan. The first cases, which is Renewal Tadman Holding Pty Ltd. The company had two directors who were also the only shareholders, a husband and wife. Both died in a traffic light. One infant child survived. The article of association required the approval of directors before shares could be transferred under the will of deceased members. There were no directors. Normally, this problem would be rectified by the appointment of new directors. However, to appoint directors, the member had to vote. There were no members. In the end, the court allowed the person representative of the deceased to appoint the directors, so that these new directors could assent to the transfer of the shares to the beneficiary. Next cases is Abdul Aziz Atan. Had the identity of a company remains independently of any change in the shareholdings of a company. The sixth effect is agency. Company employed as an agent of its controller. A company, like any other legal person, may act as an agent for its member or controllers. If a person incorporates a company specifically to take over a person's obligation, it is likely that the company will be held to be that person's agent. The case that related to agency company employed as an agent of its controller is Asprata's Berhad v Bank Bumi Putra, Malaysia Berhad. BBMB and its subsidiary BMF sued Lorraine for an accounting of secret profit that he allegedly made while he was a director of BBMB and chairman of BMF. When Wright was filled, BBMB and BMF also got injunction order to restrain Lorraine from transferring his assets out jurisdiction. The other was extended to Asprata's neighborhood. Asprata challenged the injunction order on the ground that the court should not have treated their asset as Lorraine's asset for the purpose of creating the injunction order. It was found that Lorraine exercised effective and sole control over the appellant company through his shareholdings and directorships. The court could lift the veil to determine whether assets of the company were really owned by them or whether there was an abuse of the principle that a company is a separate legal entity.
I'm Yashini Pushpanathan. To be continued, the effect of incorporation. There is control and management. The power to control and manage the company is mainly vested on the board of directors. This is provided under section 211 of the CA 2016, where the business and affair of a company shall be managed by or under direction of the board. The board has all the power necessary for managing and for directing and supervising the management of the business and affair of the company subject to any modification, exception, or in the constitution of the company. Another and last effect of the incorporation is the common seal. A company being artificial person has nobody similar to natural person, and as such is cannot sign documents for itself. Therefore, it acts true in board of directors for carrying out its activity and entering into various agreements. The common seal is the official signature of the company. Conclusion. In conclusion, incorporation of a companies thus had its own effects. Incorporation greatly depends on the needs of the business. If the members perceive the business as scalable, then the high incorporation costs are completely justified. Incorporation is a legal process in order to form a company or a corporate entity. In other words, incorporation means the registration of the company in Register of Company, known as ROC. The corporation is a legal entity that separates the income and firm's assets from its investors and owners.
That's all from us. Thank you, madam. Have a nice day.